Good day, Crime Talk aficionados. We have another wonderful show for you. First, was there another witness that saw Bryan Kohberger outside of the house? And is this woman going to testify? The Karen Reed jury asks a couple of questions. Sean Diddy Combs' trial, some explosive testimony and evidence presented today. Notebooks reveal meticulous planning by the alleged Minnesota assassin Vance Bolter. R.Kelly, remember him? Well, he's been hospitalized after allegedly overdosing in prison, and lawyers claim it's a murder plot. Kouri Richins gets a trial date set for February of 2026. We have this day in legal history, our legal quotes regarding jury duty, and done criminal of the day. A Florida man's 911 obsession hits a new high. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications because you want to know when we go live or put up new content. And remember, you can check us out on any of your favorite podcasting apps. Now, before we get to today's great docket, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you will be able to conduct as many background searches as you desire on anyone here in the United States. So whether you want to do 1, 1,000, or 10,000, you can do it, all for the same fee. And remember, you can cancel at any time. And that report is going to be prepared and emailed to you while you wait. It's going to have information about all their contact information. That's right, cell phones, emails, social media. You're going to find out if they have criminal history. Are they on a, sex offender registry, criminal history? Find that out. You're going to find out if they're married. Are they divorced? You're going to find out if they have liens and judgments. So are you going to take the plunge without checking the other person out? No, you're not. Go to crimetalksearch.com. You're going to be happy that you did. All right. One more thing before we get to the docket today. So I don't know. When did this take place? Okay. I have been a sugar-free Red Bull person forever because it only has 10 calories versus the 200 calories. 0. Red Bull 0. Where has this been all my life? Only 5 calories. Oh my gosh. Lovely Miss Kristen, we need to look for this when we go to Costco. Just saying. All right, let's go ahead and open the record for Tuesday, June 17th of 2025. And first on the docket, Bryan Kohberger. Did somebody else see Bryan Kohberger outside that house? Well, a 44-year-old woman from Moscow who worked as a DoorDash delivery driver claims to have delivered food to the residents shortly before the homicides occurred. Specifically, court filings indicate that Zana Kernodle received a jack-in-the-box order from DoorDash at approximately 3:59 a.m., just minutes before the stabbing.
And now I have to testify. Murder case here, so yeah, because I'm a DoorDash driver, so yeah. You have to testify in which murder case? Murder case for the college girl. Oh.
This woman, identified in court documents by the initials MM, expects to testify at Kohberger's upcoming trial, which is scheduled to begin with jury selection in late July and obviously really hitting the ground running in early August. Now, her testimony is anticipated to be significant because she reportedly saw the suspect, allegedly, Bryan Kohberger, near the residence during her delivery. Now, according to posts on various social media platforms, this woman claims to have parked next to Kohberger's vehicle, a white Hyundai Elantra, and made direct eye contact with him while he was allegedly looking intently at the house. Now, the woman's account aligns with other evidence in the case, including surveillance footage that captured a white Hyundai Elantra matching the make and model of Kohberger's 2015 car in the neighborhood around the time of the murders. Now, prosecutors have stated that the DoorDash delivery provides a critical timeline of events leading up to the homicide and corroborates other witnesses' testimony. Now, the driver's observations of Kohberger could serve as eyewitness evidence linking him to the crime scene. complementing other key pieces of evidence such as DNA found on the knife sheath and the scene, as well as cell phone data tracking Kohberger's movements. Now, the woman disclosed her purported involvement in the case during, guess what? Well, when she got pulled over in Pullman, Washington in 2024, and it's body cam video when she's being interviewed at the police station. Well, yeah. She mentioned to the officer that she might be called to testify in this big murder case involving the University of Idaho students. Now, her identity as the DoorDash driver was further supported by a private investigator working for the parents of the victim, Kaylee Gonzalez, who's confirmed the driver was female, and by court filings referencing her initials. Now, obviously, this development is part of a broader legal process where the prosecutors intend to seek the death penalty if Mr. Kohberger is convicted. The defense, however, is pushing to delay the trial and has raised the possibility of presenting an alternate suspect. Now, while also challenging the admissibility of certain evidence, a public hearing is scheduled for June 18th to address the defense request. That's tomorrow, ladies and gentlemen, which, as long as it's being brought to you streaming, we will bring it to you as well. Now, the DoorDash driver's testimony could be pivotal, obviously, in establishing Kohberger's presence at the crime scene, adding to the prosecution's case, which already includes physical and digital evidence. However, the reliability of her account and its impact on the trial will depend on further scrutiny during the court proceedings, i.e. cross-examination. And if you take a look at the body cam video, this little clip, she says, "I have to testify in this big hearing." And then the cop says, "So is that why you're driving under the influence of drugs or alcohol?" Something to that effect. Yeah. So clearly ripe stuff for cross-examination by the defense indeed. We'll have to wait and see, ladies and gentlemen. Hopefully tomorrow at that hearing, we'll get a little more idea of whether we're going to trial at the end of July, early August, or we're going to get a continuance. And is there going to be an alternate suspect, or are they just going with general denial? It wasn't me. Prove it. Frankly, that's the best defense ever sometimes. Next, let's also talk about if you want to participate in the Bryan Kohberger case, we have got a way for you to do it. That's right. A community-led initiative is seeking volunteers to assist in a search for a critical piece of evidence in the Bryan Kohberger case involving, obviously, the murder of the 4 University of Idaho students, Kaylee Gonzalez, Madison Mogan, Ethan Chapin, and Xana Kernodle. The trial, obviously, is expected to begin this summer, but guess what? They're missing a key piece of evidence called the knife. Now, the volunteer effort aims to locate the weapon and support the investigation. So when is it going to be? June 21st and 22nd of this year. And it's a 35-mile area along the route between Moscow, Idaho, and Pullman, Washington, specifically Highway 95 and 195. And what's the purpose? To search for a knife potentially discarded in the area, which may be the murder weapon. The organizer, a guy by the name of Jason Jensen, who is a licensed private investigator with a 30-year experience, known for working on high-profile cases such as the JonBenet Ramsey case, as well as O.J. Simpson. So the missing murder weapon is a critical element in the case. I mean, not really. It's a clue, not an element. It's a piece of evidence. And anyway, Jensen believes there is a strong possibility that the knife may be found along the specified route based upon behavioral patterns observed in similar cases. I think it's in a river somewhere, but that's just me. Anyway, court documents indicate Kohberger obviously purchased the K-bar 8 months prior to the alleged murders that he committed. And Jensen's theorizes that the weapon may have been discarded from a vehicle, drawing parallels to tactics used by other offenders. Now, this search offers a unique opportunity to contribute to a high-profile investigation and support the pursuit of justice. So if you got nothing to do, you just happen to be in the area between Pullman and Moscow, Idaho, drop on by. Who knows what you may find? You could make your way to the courtroom saying you found a piece of evidence. And what did you do with it next? I turned it over to the police. Think about it, ladies and gentlemen. This could be your 15 minutes of fame. Anyway, requirements. There are none. No prior experience necessary. Volunteers will receive instructions on search protocols. You just need the ability to walk and search outdoor areas, potentially in uneven terrain. And adhere to the protocols. Volunteers must follow instructions to avoid contaminating potential evidence. And like I said, they will be briefed on safety measures and evidence handling protocols before the search begins. And if a knife or other evidence is found, guess what? Volunteers are instructed to freeze the scene, retreat, and notify authorities to ensure proper processing by law enforcement. That search will be conducted in coordination with local authorities to ensure compliance and legal and investigative standards. And while not directly involved in the Kohberger case, Jason Jensen, the organizer, has extensive experience in weapon searches and high-profile investigations. And he notes that the items, like the missing knife, are often discovered by chance, increasing the importance of community participation. The search marks Jensen's first attempt to locate this specific knife, and he is optimistic about the potential impact of the efforts. And guess what? Like he says, you can play a vital role in helping closure for this tragic case, and you could be the one to make the difference. Next on the docket, the Karen Reed case. The jury asks a couple of questions. And when I saw what the questions were, I just shook my head. And not because I think you can say one way or the other where it's going. I mean, clearly it sounds like there's not an agreement. But one question, well, we'll get to it in a second. Anyway, today, the jury in the Karen Reed murder trial submitted 4 questions to Judge Cannoni during their deliberations. So these are the questions. What is the time frame for the OUI, operating under the influence, charge? Offense 002, Section 5-OUI at 12:45 or OUI at 5 a.m. This question sought clarification on the specific time the alleged OUI offense occurred, as the prosecution and defense presented different timelines regarding Reed's alcohol consumption and driving status. Obviously, and then the next one, this is one I just don't get. Are the video clips of Karen's interviews evidence? How can we consider them? The jury asked whether the media interviews given by Miss Reed, which were played during the trial, constituted evidence and how they should weigh their statements in those clips. Oh my gosh. Yes, it's evidence, ladies and gentlemen. Anything a defendant says can and will be used against them. And the fact that 32 days of trial and 2 days of deliberation, this is the question they're asking. Oh, that's why we have our legal quotes of the day. Okay. Oh my goodness. Anyway, does convicting guilty on a subcharge, example, offense 2, number 5, convict the overall charge? This question addressed the confusion about the verdict slip for the manslaughter while operating under the influence charge, specifically whether convicting Reed on a lesser included offense, operating under the influence, would automatically result in the conviction of the main charge. No, ladies and gentlemen, that's why it's a lesser included offense. That's why you start at the top first and you say, okay, here is the charge. If you don't believe the government's proven their case beyond a reasonable doubt, you can then go to the lesser included offense, which the defense asked for. Now, wouldn't that just be, that's why you always question whether I ask for lesser included offenses, because what if they are not guilty on that, but they convict on the lesser? Ooh, ouch. But that's a request the defense makes. Prosecution can get it too, but usually the defense does it. Prosecutors usually don't want the defense to get a lesser included charge. They want the charge that they went to trial on, unless something went horribly bad at trial. Next, if we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? This question indicates obviously the jury might have reached a consensus on 2 of the 3 charges, second-degree murder and manslaughter, while operating under the influence and leaving the scene of a crash resulting in death, but were divided on 1, and they sought guidance on whether this could result in a hung jury for all of the charges. Anyway, the judge responded as follows. For the first question, she declined to specify a timestamp, stating, "You folks have the evidence. It is only you who decide the facts in this case," emphasizing the jury's role as the fact finder. For the second question, she confirmed that the video clips were evidence and instructed the jury to weigh the defendant's statement in the videos as you would with any other evidence. Give them what other give them whatever weight you deem appropriate. For the third, she provided an amended verdict slip for the manslaughter OUI charge with the additional language to clarify the options, addressing the jury's confusion. For the fourth, she deemed it a theoretical question and responded, "This is not a question I can answer." After defense attorneys, Alan Jackson argued that a more specific response was needed to avoid confusion. Obviously, these questions suggest that the jury was grappling with the complexities of the OUI-related charge and the evidentiary weight of Reed's public statements and the procedural implications of a partial agreement on the charges. Ladies and gentlemen, like I said, I've had hundreds of jury verdicts. Terrible. Okay. Worst two parts of any trial. One, waiting for the verdict. And then the worst part is when they say they have a verdict. It's the worst. You can't do anything. You're told to be 5 minutes away from the courthouse so you don't leave. You can't really get any other work done because you're so distracted. And sometimes you get a question and you think, whoa, that's good. And it comes back bad. And sometimes you get a question you think is, bad and it comes back good. And usually what my experience is like there's somebody wants a question answered to make them feel, comfortable. And usually after questions are asked, we get a verdict. Now, I don't have a crystal ball, and anybody that says that they can predict what's going to go on, even in light of those questions here today, you never know. You never know. Until they read that final verdict, you never know. They can change their mind. Somebody can go think about it. Like I said, the jury may be getting close. They could say, you know what? Go home, sleep on it tonight, and we come back tomorrow morning. We'll talk about it, fresh minds, and we'll see where we go. So I would expect maybe tomorrow morning the verdict. Like I said, I don't have a crystal ball. That's a guess. Just like everybody else was predicting a quick not guilty or a quick verdict. It was a 32-day trial, ladies and gentlemen. These people are going to take their time. They're going to try to get it right based upon what they believe is correct, based upon the facts and the law. They decide the facts. They decide how those facts fit into the law. They got to follow the law whether they like it or not, to make a decision with neither passion nor prejudice. Like I said, if there weren't thousands of people standing outside the courthouse showing support for this lady, and maybe these people feeling a little scared and intimidated, listen, you try this case 100 times, you're probably going to get a jury verdict of guilty 99% of them. It's that simple. I'm a defense guy, and I'm still thinking, hey, but if that's what I will respect whatever decision the jury comes back with. Guess who also is going to be waiting on a jury here real soon? Old Sean Diddy Combs. And there was some explosive testimony today. So the ongoing sex trafficking and racketeering trial of Sean Diddy Combs there in New York reached a critical point today as jurors were presented with compelling evidence and a little bit of testimony. Now, the prosecution showcased records, videos, and witness accounts that painted a troubling picture of the disgraced hip-hop mogul's alleged misconduct, while the defense attempted to counter these claims with strategic moves. Here we go, ladies and gentlemen. Damaging hotel bill and the freak-off videos. So the jury was shown a staggering $43,000 bill for damages to a hotel suite allegedly caused during one of Combs' notorious freak-off events. These drug-fueled multi-day sexual marathons are central to the prosecution's case, which accused Combs of using his wealth and influence to coerce women and employees into fulfilling his sexual and sometimes violent desires. And jurors viewed approximately 18 minutes of explicit video extracted from a phone belonging to Combs' ex-girlfriend, Cassandra Cassie Ventura. The footage, recovered from a Frank Black user profile, depicted Ventura with male escorts during sessions back in October of 2012, as well as in December of 2014. The jurors appeared visibly affected, with some displaying discomfort or disbelief as they watched the clips through, obviously, video monitors and with headphones on. Yes, ladies and gentlemen, that's called the prosecution made the jury watch porn. That's the evidence. They got to watch it. What can you do? Anyway, prosecutors announced on Tuesday morning that they expect to rest their case by Wednesday, but delays in summary witness testimonies pushed this timeline back. So a key witness, Brenda Paul Combs, former assistant, alleged drug mule, is scheduled to testify on Wednesday. Paul, arrested for drug possession during raids on Combs' home in March of 24, took a plea deal, which may bolster the prosecution's narrative. Now, summary witnesses include Special Agents Delicia Penland from the U.S. Attorney's Office, presented charges combining texts, calls, hotel records and flight data to illustrate Combs' coordination of freak-offs. Basically, what they do is they get all the records, they put somebody up on the stand to explain this is what it all means, and this is why we tie it all together. Now, one notable record showed a $7,000 bill for a 2-night stay at the Four Seasons in Los Angeles for an additional $495 charge for a second room allegedly used for freak-offs. Now, Combs' legal team worked to undermine the prosecution's claims. Their attorneys cross-examined Ms. Penland, focusing on text messages where Ventura appeared enthusiastic about freak-offs, suggesting her willingness to participate. The defense also showed jurors similar texts from Ventura to portray her as a consenting party, a tactic they employed during her earlier cross-examination. Now, sources close to the trial reveal that Combs has taken an active role in the defense, passing dozens of notes to his lawyers daily and suggesting evidence to counter these allegations, or at least, questions. His engagement has earned him the nickname the quarterback of his legal team, as he leveraged his street smarts to navigate the courtroom. Well, the judge, he wasn't amused really today. He maintained tight controls over the proceedings, and yesterday he cleared the courtroom to discuss an unspecified matter after receiving an application to do so, possibly related to concerns about a juror discussing the case with a former colleague. Earlier, the judge dismissed a juror due to inconsistencies in their residency requirements and replaced them with a white male alternate who enjoys country music, contrasting with the dismissed juror preferences of 90s hip-hop. The judge also warned the attorneys and threatened sanctions for potential leaks from a sealed hearing, and emphasized that future violations could lead to criminal contempt penalties. Now, testimony from a witness using the pseudonym Jane revealed disturbing role-playing scenarios where Combs cast himself as Michael Jordan, the basketball player, Jane as Kobe Bryant, and a male escort as Shaquille O'Neal. This added to the prosecution's portrayal of Combs' alleged sexual fantasies. Text exchanged between Combs' staff, including Chief of Staff Christina Courtroom, highlighted their role in preparing for the freak-offs, discussing cash deliveries and supplies like baby oil. The jury also reviewed communications from March of 2016 following Combs' assault on Ventura at that international hotel in Los Angeles, where he made relentless calls and sent manipulative texts, including false claims about police involvement. I don't know, ladies and gentlemen. That's another weird one. This is what happens, when you get involved in litigation. Your whole world gets exposed. And I don't know whether Combs will be convicted or whether he will not convicted, maybe found not guilty. I don't know. The question is, was it criminal enterprise or was it all consensual freakiness by people engaging in complete debauchery? Because, well, that's what rich and wealthy people do, apparently, and famous people do. I don't know. Never been there. Wouldn't know. Anyway, who knows? Just very, very interesting, weird case. We'll have to see how that comes out. The word on the street is that Combs isn't testifying. We'll have to wait and see. Next on the docket, some notebooks reveal some meticulous planning by the alleged Minnesota assassin Vance Bolter. That's right, police have uncovered chilling evidence in the case of Vance Bolter, the 57-year-old resident of Green Isle, Minnesota, charged with stalking and murder of State Representative Melissa Hortman and her husband, Mark, as well as stalking and shooting of State Senator John Hoffman and his wife. Now, these notebooks found in Bolter's car and a residence where he rented a room in North Minneapolis provides a bit of a disturbing glimpse into the alleged meticulous planning behind the attacks. Now, this is all according to the United States Attorney up there in the District of Minnesota. There's also been a lot of photographs released by the United States Attorney's Office revealing handwritten notes in Bolter's notebooks listing websites used to locate the home addresses of state and federal elected officials. The notes specify whether the services were free or paid and included detailed property information. Now, police report that more than 45 Minnesota officials were named in the notebook, indicating a broad scope of potential targets. Now, additional evidence was recovered from Bolter's SUV and included a GPS device with a, quote, trip history, end quote, containing the addresses of Representative Hortman's home in Brooklyn Park, Senator Hoffman's home in Champlin, and at least 2 other state officials. Now, the discovery underscores the calculated nature of Bolter's alleged actions. And, there's also a weapon cache and disguise. Investigators found a significant cache of assault-style rifles, ammunition, and tactical gear inside of Bolter's vehicles. And a search near Hortman's residence also uncovered a disassembled semi-automatic handgun, 3 magazines, a tactical body armor vest, and a flashlight. Most notably, a latex mask resembling a bald elderly man was discovered near Bolter's home, and police confirmed that the mask matches descriptions from the security footage capturing Bolter on the night of the killings, suggesting, obviously, that he used the mask. Now, Bolter's arrest followed the largest manhunt in Minnesota history, including on Sunday night when he was apprehended in a field less than a mile from his home. And a witness by the name of Wendy Thomas recounted a pivotal moment when she spotted a figure lurking in the grass near a friend's home in Green Isle. Now, initially mistaking the individual for a law enforcement officer, Thomas grew alarmed upon realizing the person was alone with no vehicle nearby. She was shaking. She was freaking out, she told reporters. And after alerting police, she directed officers to the suspect's location and ultimately led to Mr. Bolter's capture. She's going to get to testify in court. Anyway, Thomas expressed shock that Bolter remained in the area after the extensive 2-day manhunt, and she didn't think that he'd be in the area, but figured, he'd be gone. Anyway, Mr. Bolter now faces charges of stalking and murdering Representative Hortman and her husband, as well as stalking and shooting Senator Hoffman and his wife, as announced by the acting United States Attorney Joseph H. Thompson. Now, the attacks have heightened concerns about the safety of elected officials, prompting discussions about enhanced security measures. And this case also highlights Bolter's disturbing background, including his work extracting eyeballs from corpses, a job that kept him on call the night of the double murder. Good alibi. I was extracting eyeballs. It couldn't have been me. Anyway, the investigation continues as authorities process the evidence recovered from his home, and the United States Attorney's Office has not released further details about potential motives or additional targets, but emphasized the gravity of the findings in the notebooks. It was a political hit, ladies and gentlemen. It's an assassination of a political figure, something we don't have a whole lot of here in the United States. I guess they tried it on now President Trump in Pennsylvania, but he survived. This is just as egregious. I don't care if it's a state rep, state senator, any politician. They should be able to do their job. If you don't like them, vote them out. You don't go killing them. Next on the docket, R.Kelly hospitalized. You remember him, right? And his lawyers claim that it was a murder plot. So let's banter on over to Butner, North Carolina. And the disgraced R&B singer R.Kelly, currently serving a 30-year sentence for racketeering and sex trafficking, was rushed to Duke University Hospital last week following an alleged overdose on medication administered by prison staff, according to court filings by R.Kelly's legal team. The filing, submitted on June 17th, further alleges that the overdose was part of a deliberate plot by the Federal Correctional Institution, FCI Butner, staff to kill the singer, whose real name is Robert Sylvester Kelly. Anyway, Kelly's attorneys claim that on June 10th, the 58-year-old was placed in a solitary confinement holding area, a move they asserted was retaliatory after they filed an emergency motion alleging that 3 Bureau of Prisons officials had orchestrated a plot to have Kelly murdered by another inmate. The earlier motion, filed on June 10th, included a sworn declaration from a guy by the name of Michael Glenn Stein, a terminally ill inmate and self-identified member of the Aryan Brotherhood, who alleged that prison officials offered him freedom in exchange for killing Kelly. Stein claims that he was transferred to Kelly's unit in March to carry out the act, but ultimately informed Kelly of the plot after reconsidering. The filing also alleges a second plot in June targeting both Kelly and Stein by another Aryan Brotherhood member. And according to this filing, while in solitary confinement, R. Kelly was given an overdose quantity of regular anxiety and sleep medication on June 12th with instructions to take it. On June 13th, Kelly awoke feeling faint and dizzy, experiencing black spots in his vision. He reportedly collapsed, crawled to the cell door and lost consciousness. Prison staff transported him to Duke University Hospital, where he was hospitalized for 2 days. Now, the pleading claims that during the ambulance ride, a prison officer remarked, "This is going to open a whole new can of worms." Kelly's legal team alleges that doctors discovered blood clots in his legs requiring surgery, but prison officials denied the procedure and forcibly removed him from the hospital against medical advice. Kelly's attorneys further assert that the singer has been mistreated at FCI Butner, including being denied necessary treatment for ongoing blood clot issues. They claim that within the past 3 months, prison medical staff discontinued his blood thinner medication without explanation, increasing his risk of serious complications. The filing described Kelly as in tears, fearing for his life, and alleged that the overdose occurred just days after his team exposed the alleged murder plot, suggesting a coordinated effort to silence him. Well, federal prosecutors have dismissed Kelly's claims as deeply unserious and fanciful, arguing that this allegation mocks the harm suffered by his victims. And they noted that Kelly's placement in solitary confinement demonstrate prison's official efforts to ensure his safety. Needless to say, it be declined to comment, citing pending litigation, and Kelly's legal team has renewed their request for his release to home detention and is seeking a presidential pardon, stating they are in discussions with individuals close to President Donald Trump. They argue that Kelly's life remains in jeopardy and that he cannot wait for judicial vindication. Now, for those who don't remember, Mr. Kelly was convicted back in 2021 in New York on racketeering and sex trafficking charges. Hello, P. Diddy. Followed by a 2022 conviction for child pornography and enticement of minors. Evidence in the New York trial included testimony from 10 victims, supported by video and DNA evidence, while the Chicago trial revealed Kelly's sexual exploitation of underage girls, some as young as 14, which, well, he videotaped. Sentenced to 30 years in New York and 20 in Chicago, with all but one served concurrently, Kelly has been incarcerated since July of 2019 and is eligible for parole in 2045, just around the corner, and he'll be 78. His appeals have been upheld, and he remains at FCI Butner, a facility previously housing Bernard Madoff. Now, the allegations of the murder plot and overdose have intensified scrutiny of Kelly's treatment in prison, though prosecutors maintain that these claims are all manipulative. The hearing is scheduled for June 20th before the U.S. District Judge Martha Packold will determine whether the court has jurisdiction over Kelly's release request. As the legal battle continues, Kelly's attorneys insist that his safety depends on immediate. Well, when you go to prison, everybody's life is in danger at any given time. People will try to kill you. I'm sure prison guards have been involved. I'm not saying they are in this particular case, but usually they turn away, right? What is it with those little things? I want to get one of those little things that says, no, I don't want to, we're not even going there. Anyway, who knows, ladies and gentlemen? We'll see. Somehow I don't think Mr. Kelly is going anywhere except back to solitary. Next, Kouri Richins finally gets a trial date. And guess what? It's not until February of next year. So after years of legal proceedings, Kouri Richins, a children's book author charged with the murder of her husband, Eric Richins, has a confirmed trial date. The trial is set to commence on February 23rd, 2026, with jury selection scheduled on February 10th of 2026 in Summit County, Utah. Now, Richins faces felony murder and homicide charges related to Eric's death back in 2022, allegedly caused by a lethal dose of fentanyl laced in a Moscow mule. So is it Moscow or Moscow? Anyway, prosecutors claim the act was a deliberate attempt to secure Eric's life insurance. And in addition to the murder charges, Richins is accused of financial crimes, including mortgage and insurance fraud. Now, this case has obviously experienced several delays since Richins was charged back in 2023. A significant setback occurred when her initial attorneys withdrew, and further postponements followed by a failed attempt to move the trial out of Summit County. Now, Richins' defense argued that the extensive media coverage necessitated a venue change. The judge denied that motion back in April. The Utah Supreme Court upheld the decision, clearing the path for trial. So both the defense and the prosecution requested an expanded jury pool and an in-person juror questioning that the judge rejected those motions, a ruling affirmed by the appellate court. So after 2 years in jail, everybody is currently quite relieved that Miss Richins has a trial date, and she is ready for the truth to come out and for the false narrative that have defined the case to be confronted in a court of law. Her team is confident that once the facts are heard, it will be clear to all that Kouri is innocent. Start that PR campaign now. Free Kouri Richins. Free Kouri Richins. Oh my gosh, FKR. Isn't that the same thing? Free Karen Reed? They could like duplicate it. They could like totally just do it. Anyways, the trial approaches, the case is going to draw a lot of attention because Miss Richins has maintained her innocence and preparing to face the allegations in court. Next on the docket, this day in legal history. On June 17th, 1861, federal authorities were prosecuting Confederate sympathizers for treason, shaping legal precedent on rebellion and loyalty during the Civil War. 1933, gangster Pretty Boy Floyd and associates ambushed law enforcement at a Kansas City Union station, killing FBI agent Raymond Caffey, Chief Ott Reed, and Detective Grooms and Hermanson. This led Congress to authorize FBI agents to carry firearms and actually make arrests. Go figure. And on this date, June 17th, 1963, in the case of the Abington School District versus Shemp, the United States Supreme Court ruled mandatory Bible readings in public schools was unconstitutional. And on this date in 1971, President Nixon popularized the term war on drugs during a press conference declaring drug abuse public enemy number one, launching national anti-narcotic policy. All those years later, and it's still haven't solved the problem. You're not going to, as long as you got people that want to do it. Just saying. And on this date in 1994, O.J. Simpson was arrested following a televised low-speed chase and charged with the murders of Nicole Brown Simpson and Ronald Goldman. Who wasn't watching that? I know I'm probably dating myself, but I remember watching it. Everybody watched O.J. drive in the white Bronco with his buddy, and then the police following like at 45 miles an hour behind him. Next on the docket, a couple of legal quotes regarding jury duty. 12 people good and true, otherwise unemployable. That was from my contracts law professor, because when we talked about it, when you go to a jury, you never know what you're going to get. Here's another one. When you go into court, your fate is in the hands of 12 people who weren't smart enough to get out of jury duty. Think about that one for a minute, ladies and gentlemen. I trust the jury system. I do. And I will respect it. Whatever happens, for example, in the Karen Reed case, just like I've had to do in cases where I've lost, perhaps even where an appeal's gone up and the case got reversed. I respect the jury because they were following the law that the judge gave them, and they applied the law to the facts. If somebody gets an unfair trial, it's usually the judge that does it, not the juries that screw it up. So you got to respect the jury decision, regardless of whether you like it or not. I will. And next, our dumb criminal of the day. A Florida man's 911 obsession hits new heights. Please meet Samuel Lee Thomas, a 72-year-old St. Petersburg resident, and he has dialed 911 a staggering 3,400 times this year alone, racking up 16,000 calls over 5 years. His latest stunt? A false report of an AR-15 shooting that turned out to be a family barbecue with kids playing. Neighbors confirmed no gunfire occurred, just Thomas's relentless grudge against, the neighbor across the street. Now, Thomas bombarded police with 647 complaints this year about the neighbor's home, alleging drug deals, gunplay, and general mayhem. None were substantiated. Now, Peterson, fed up with hundreds of police visits and Thomas's shouted obscenities, fears his calls could spark real danger. Police agreed, arresting Thomas for stalking, false reporting, and resisting arrest after a brief scuffle. Undeterred, Thomas is out on a bond. He pled not guilty, claiming he's just reporting neighborhood nuisances. His rap sheet includes battery, DUI, bad checks, and more. Suggests a knack for trouble, but no prior 911 misuse. Mental health or substance issues? According to the police, nope. Just a man with a phone and a vendetta. You gotta love that, ladies and gentlemen. What could possibly go wrong? All right, ladies and gentlemen, we made it through another episode of Crime Talk today, and I'm gonna go crack this Red Bull Zero open. Who knew? Who knew it even existed? Thanks, Frank. All right, everybody. Have a wonderful day. We'll see you tomorrow. And remember, the Constitution matters.